Hello, and I welcome you all to the second lecture of the law of evidence. In the first lecture, we have read about the law of evidence, introduction of the law of evidence, history, and what do you mean by facts and issue, and also we have got the introduction of what is the meaning of relevant facts. In this lecture, we would be dealing with four topics that are relevant facts, difference between facts and issue and relevant facts, evidence and its types, fourth one being proved, disproved, and not proved. All these three are three words that are very prominent for the law of evidence, and we would be dealing with the meaning and distinction of proved, disproved, and not proved. Moving further, the first thing that we need to discuss is what is the difference between the facts and relevant facts. Facts and issue, as we have already learned that facts and issue are nothing but the question in dispute, okay, which are alleged by one party and denied by the other party. As in the case of murder, one party would be stating that A has committed murder, okay, and the other party would be stating that A has not committed the murder. The point of contention that A has committed the murder with the intention is the facts and issue in the present case. And on the other hand, what is the relevant facts? Relevant facts are those facts which are essential to prove the facts and issue, which are essential to prove that there exists a liability, there exists a duty, there exists a right, okay. So uh, in this example as I have given, if one of the party proves that the accused was in possession of the murder weapon, that is the possession of murder weapon is what a relevant fact of this case. So this is the basic difference of relevant fact and uh, facts and issue. Let's learn point by point how facts and issue and relevant facts are different. The first point being the facts and issue is a necessary ingredient of a right or liability. As I have stated, facts and issue is nothing but the necessary ingredient of the offense with which the person is charged. So definitely in order to prove the right or liability of a person, it is necessary to prove the facts and issue. Likewise, in the case of murder, it is necessary to prove that the accused had the intention. Okay, intention being what? A very important ingredient of a murder. So, there is a need to prove that there was an intention, and that proving the facts through which the intention would be proved, that would be a facts and issue. And relevant facts is not a necessary ingredient or right or liability. It merely renders probable the existence or non-existence of any ingredient of a right or liability. It merely states that whether the intention, the rights or liability exist or not. In the case of murder, the facts, all the facts that shows that there was intention of the accused to murder ABC, this shows what these are all the relevant facts showing that there was a previous family dispute between A and B, between the murderer and the victim. These facts are what? These facts are known as relevant facts. These are not facts in issue. The second point being a fact in issue is called principal factum probandum. It means that all the principal facts which are necessary to prove the existence of any right and liability. Factum probandum means all the necessary and the principal facts that need to be there to prove any liability or right. Okay, so the word factum probandum means that. A relevant fact is a key evidential fact or factum propendi. Key evidential facts include the murder weapon, include, okay, in case of robbery, it will include all the arms the robbers were carrying. Okay, the CCTV footage. All these are what very important evidential facts, and what we call them factum probendi. And factum probandum, on the other hand, are the essential things that need to be proved in order to prove any case. Okay, the third thing is that fact and issue are the matters which are in dispute. They are the facts out of which some legal rights or liability necessary arise and upon which a decision must be arrived at. As I have stated, facts in issue are the ingredient or essential of the crime. So it is necessary, it is very necessary for the court to decide the facts in issue. Then only it can come into a decision. They are the matters which are affirmed by one party and denied by the other party. Okay, I have already explained that facts in issue are always accepted by the one party and denied by the other party. The relevant facts being are not themselves an issue. They never form an issue, but the foundation of inference regarding them. They are never considered as an issue, but what are they? They are the foundation. If the murder weapon is found with the accused, then only he would be charged with the intention. Then only the question of intention would arise. Okay, so relevant facts are not themselves issue, but the foundation of them. Let's understand this difference with an example. So, in fact, in issue we are having an example. A is accused of murdering B. Issue number 1. Whether A caused B's death. Whether A is intended to cause B's death. All these are what? Facts in issue. These are the facts which are in dispute. Okay, these are being accepted by the one party. These are being claimed by one party. No, A had the intention, and denied by the other party that A did not have the intention, did not killed B. So here, and on the other side, if we read about the relevant facts, for the allegation of murder, A sets up the plea of alibi that at the occurrence of the murder he was at a distant place. Distant means काफी दूर की जगह है, मतलब he cannot commute to the place of incidents in a reasonable time. Okay, the fact that he was at the other place, the fact that he was at the another place at the same time, these are what? These are what? Relevant facts. These facts constitute facts which would be relevant in proving the facts in issue. Okay, so these are the example and difference between the facts in issue and relevant facts. So let's move to the next topic. Okay, so we read about many things. We first read about the facts. We read about the facts in issue. Then we read about the relevant facts. Now what we are reading about? We are reading about the evidence. Okay, evidence which is the most important. In Hindi we call sakshi. Okay, evidence. Any fact is not evidence at first. It becomes evidence when court permits or allow it in the court of law. Then only any fact or anything becomes evidence. Okay, evidence is a legal word. It's nothing a logical or natural word. It's a very legal word. Okay, section 3 is the interpretation clause of Evidence Act. So all the definition regarding the evidence, regarding the facts in issue, regarding the relevant facts, you will find in the section number 3. Always do never forget about section number 3, and there is no marking like A, B, C, D, so you don't have to get confused okay, what numbering was it. It would be always section number 3. Okay, section number 3 states that evidence means and include, again as I have stated earlier also, and again I am stating, whenever you will see the word means and include, it means that it is providing a very exhaustive, a very complete definition of the word. Okay, when the word is means, it also defining the words, and the other word includes, it's also defining the ambit up to which it can be stretched out. Okay, so section number 3 of Evidence Act states that evidence means and include all statements which the court permits or required to be made before it by the witnesses. Again, the word the court permits or requires. It's not stating which is made in the court of law. No, when the court is permitting and requiring any person to state anything, then only it will get the evidence. Anybody blabbering anything will not be administered as an evidence. Only when the court is asking XYZ person to come in the court and stand in the witness cabin and say something, then only it will register as an evidence. Okay. In relation to the matter of fact under the inquiry, okay, the second main point or the main ingredient of evidence is what? in relation to the matter of facts and inquiry. It need to be very related to the inquiry. It should not be arbitrarily stated. Okay, no, nothing which is not related to the case cannot be registered or administered as an evidence or testimony. Okay. Second, if we state that the word here is what? Statements. The word here is what? Documents. So the first clause is stating about oral evidence. The second clause is stating about documentary evidence. Okay, these are what? Documentary evidence. All documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. Why electronic evidences are documentary evidences? Because after the 2000 Amendment Act, now the IT Act has incorporated itself in pursuance of Indian Evidence Act only. It was a major amendment, and now we include all the electronic evidences, SMS, camera reading, okay, and email, text. All these are what? These are electronic evidences, and we would be reading in 65B and how these evidences are administered. Okay. According to the definition, there are two kinds of evidence. First, that is oral evidence. The second one is documentary evidence. Okay, but there is a catch here. It is not exhaustive. Okay, the meaning, the kinds that the section number 3 is defining is not exhaustive in itself. There are many more type of evidences that we observe, that court observe. Likewise, circumstantial evidences, direct evidences, primary and secondary evidences. Okay, so all these evidences are also very much part of and very much administered and admissible in the court of law. So these two, oral and documentary evidences, are just the primary evidences, just are like, we can say it's just topping the list of types of evidences. There are numerous other type of evidences that we would be learning further. Okay, so types of evidences here classify as two, oral and documentary, as I have stated. But besides this, there are many divisions like circumstantial and direct and circumstantial. Direct means if I have to give an example of direct evidences, it means like eyewitness would be a direct evidence. Circumstantial evidences, like if XYZ person saw your car saw the car of the accused to be at the point of to be at what we can say to be at the incident place, then that would be circumstantial evidence, so that he might be there. It is not direct evidence. Nobody has seen that person to shot the other person, so that would be what circumstantial evidence. So we are interpreting the circumstances, that all the circumstances are leading to an inference. We are interpreting the circumstances to form an inference. Okay, that would be what circumstantial evidences. The second is real and personal evidence. Okay, the third one being original and unoriginal, that is primary and secondary. We would be dealing with 64, 65, like original evidences, like original, if I have signed on a paper, okay, the paper would be original. Unoriginal means a photocopy of it, that would be secondary evidence. Substantive and non-substantive evidences, like corroboration is sometimes it is considered as a non-substantive evidences, and sometimes it is sometimes contradiction is considered as a non-substantive evidences. Positive and negative. Positive, it's showing a positive impact on the case, that would be positive, and negative, and that is showing a negation or negative impact on the case, that would be negative evidence. So all these are the kinds of evidence that exist other than the two, oral and documentary evidences. But as after analyzing all the PYQs, I have came to know that the DO only focused on the oral and documentary evidences and has not extended its ambit to the other evidences, so you don't need to be worried about it. So let's start reading about what is the meaning of documentary evidence. Documentary evidence, there's a definition which is provided, and again as I have stated, all the definition, where you will find all the definition, section number 3. Section number 3 states that any matters which is expressed or described on any substance, it's not paper, on any substance. Again, any matter written on a leaf is equivalent to a what? A documentary evidence. Okay, any substance by means of letter, figures or remarks, or by more than one means, and which can be used for recording the matter, is considered as document. Okay, all these things, anything, anything expressed or described on any substance, okay, by means of letter, figures and word, or more than one of these, okay, and which can be used, there is an and here, okay, which can be used for recording the matter. There need to be an intention to record the matter. There need to be a utility that that thing can be used to record that matter. All these things are known as, are considered as document. Okay, let us go through some of the illustration. You can open your barrack and see some illustration. Section number 3 has some interesting illustration regarding the definition of documents. The first illustration here is a writing is a document. Definitely, as I've stated, a writing is a document. Second is what printed, lithographed or photographed are documents. So here by this illustration it is very clear, all the photographs are what? They are documents. They are documentary evidence. If anybody has to present any documents in the court of law, that would be what? A documentary evidence. That cannot be a oral evidence. Okay. A map or plan is a document. A map, it may be a very picturesome, but it is a document. It is considered as a document. An inscription on a metal plate as or stone is a document. As I have stated that it need not to be only paper, it can be anything, it can be a metal plate, it can be a leaf or anything. So an inscription, because inscription is what? They are trying to describe themselves, they are trying to preserving it in form of figures or anything, any picture they are needing, they wanted to draw. So all these things are what? Documentary evidence. A caricature is a document. Yes, caricature is what? Cartoons. Okay, so all these are what? Documentary evidence. You can also add two other evidence as documentary evidence. The first one being electronic evidence and second one being tape recorded statements. These are also what? Documentary evidence. We also prove the tape recorded evidence as documentary evidence. We follow the same procedure as documentary evidence. Okay, moving if you know about it, the Praful Desai versus State of Maharashtra was the case where the tape recorded statements was first held as legit evidences and was first, this was the first case where tape recorded statement was admissible, was held admissible in the court of law. For a future reference. Okay, so example of documentary evidences, I have already given you plenty. Postmortem report, electronic evidences, all the official documents are what? Documentary evidences. Okay, section 62, 63 and 91 of the Indian Evidence Act deals with documentary evidences. We would be dealing it with further, but let me give you a brief about 62, 63 and 91. Okay, 62 deals with, just a second, 62 deals with primary evidence, 63 deals with secondary evidence, and 91 deals with proving the contract or grant of disposition with the help of documentary evidence. All these you would be learning further. Now coming to the oral evidence part. This is what the second type of evidence that we would be going through. Okay, section 59 of the Indian Evidence Act states that the proof of facts by oral evidence. Okay, section 59 states that all the facts, if anything has been proved by oral facts, that such oral facts need to be direct. Okay, what is the meaning of facts need to be direct? It means that the one who saw it, the one who feels it, the one who has perceived it, must be the person who is stating the facts in the court of law must be the person who has seen it, who has perceived it. Okay, let me explain you with an example. Like if I say that XYZ dish tastes very sweet to me. So I should be the one who has perceived that taste to state it in the court of law. Okay, if I saw a stranger to beat the victim, I should be the one who would be stating it in the court of law. Not any other person can do it. Okay, and if anybody else is doing it, that would be an indirect statement. Okay, that won't be a direct statement. And after reading section 60, you would be knowing that oral evidence shall be direct evidence. Okay, section 60 states that oral evidence must be direct evidence must in all case whatever be direct, that is to say that it refers to a fact which could be seen. It must be the evidence of a witness who says he saw it. Okay, if it refers to a fact that a person that could be heard, it must be the evidence of the person who says he heard it. Heard means like if in the case of domestic violence, he's giving an evidence that he has saw that the husband and wife fought together every night, that he should be, and he has heard the noises, then he should be the one who would be stating it in the court of law. Nobody else can do it. Okay, if it refers to a fact that could be perceived by any other senses or in any other manner, it must be the evidence of a person who has perceived by that or by the other senses. Okay, if I am stating that there was a foul smell that was coming from the flat of the victim, then I should be the one who should be stating it, that there was a foul smell. Okay, if I hold an opinion, the last part state that if a person holds an opinion regarding anything, then he should be the one who should state it. Okay, if I am stating that the victim, or if the accused more appropriately, holds a bad reputation in the colony, and he used to fight with everyone. Okay, so I should be the one who should be stating it. Same goes with the expert opinion. Okay, whenever an expert is forming an opinion about regarding, let's say, handwriting, expert is forming an opinion regarding handwriting of the accused, then he should be the one who should state it in the court of law. Nobody else can do it, not even his assistants. Okay, so this is what direct evidence, this is what oral evidence, and that need to be direct. Section 60. The case law on this is Queen Emperor versus Abdullah. This is a very famous case regarding section number 8 that deals with motive preparation, that we would be learning further. But in this case, what happened? The victim was the deceased was brutally raped, and he could not speak. Okay, so that's why he uses his hand. Okay, he uses her hand, okay, to sign who was the one who slit his neck. Okay, so what court did in this case, court consider all the gestures as oral evidence. Okay, so reading it, where the woman was unable to speak because her throat was slit, and she suggested the name of her assailant by sign or her hand, the court held that it constituted oral evidence. Okay, so this was a what we can say a advanced version of definition of oral evidence. Oral evidence is basically the word of mouth, but here the signs that was done by the deceased was considered as a part of oral evidence. Okay, so this is a breakthrough case in the oral evidence category, so that's why it is important. Now let's have a brief discussion about proved, disproved, and not proved. Okay, proved means uh, let's uh, let's have a discussion regarding what is the meaning of proved. A fact is said to be proved when, after considering matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon that supposition. Okay, so here as we have read about the proved, that a fact is said to be proved when after considering the matter before it. What is the catch here? After considering the matter before it. Okay, the court has to consider the matter, has to hear the matter, then only it can state that any facts to be proved. Okay, the court, it is a discretion of a court, not of the parties, either believes it to exist, क्या वो exist करता है, or consider it, sorry, और consider its existence so probable, probable मतलब reasonable, कि हाँ ये तो होगा ही. Okay, that a prudent man out under the circumstances of the particular case to act upon the supposition of that it exists. Okay, so proved means when the court after considering all the aspects of the fact consider that such facts definitely exist, or even if not definitely exist, the court thinks that it has all the chances, all the probability of the existence, then court can claim such facts to be proved facts. Okay, here the example is A murdered B. After murdering the evidence adduced by the prosecution and accused, and after hearing the arguments of both the parties, the court concludes that A murdered B and convicts A under the section 302 with imprisonment for life. The fact of murder committed by A is said to have been proved by the evidence adduced by the prosecution beyond reasonable doubt. Here, this fact that A has murdered B has been proved beyond reasonable doubt, and court has also considered it. Okay, so hence this fact is what? A proved fact in the court of law. Okay, so this cannot be disproved or cannot be held in the category of not proved. Now, disproved. What is the meaning of disproved? A the meaning of disproved is completely opposite of proved. It states that a fact, the court, when court after considering the matter before it consider that the fact does not exist, or thinks that even if even if the non-existence of the fact is so probable that any man would not believe that such facts exist, like fairy tales. Like if I say existence of unicorn, nobody can accept, nobody thinks that it exists. Okay, this existence, this non-existence is so probable that all the prudent men would consider that okay, it cannot be existed. Okay, if a person was found in Calcutta, let's say, at the time of incident, and the incident occurred at Delhi, so no prudent man can think that such person was present in Mumbai, or in Delhi at the time of incident. Okay, so these things are what? These facts are what? These facts are beyond reasonable. These are beyond reasonability. Okay, and these facts you don't need to disprove it. These are automatically considered as disproved. Okay, so let's see an example. Okay, here what example is stating that again it was opposite of the earlier example. In earlier example, A proved that B has murdered him. Okay, murdered A. Okay, now here the fact is proved that A has not murdered B. Okay, so this is what? A disproved fact. Okay, and not proved means what? Something which has not been proved and not been disproved. Okay, here the example state that there was a case of murder and murder of B. Okay, C and D was called as a witness. C died before coming to the court. He died, and D stated in the court that I do not know about the case. I was not there. I could not I could so that I could not answer your questions. So what is happening here? The fact that whether A has murdered B or not is has remained what? Has remained disputed, and no evidence has been adduced. So it is neither proved and not disproved. So this is what we call this fact. This fact is what? Not proven. Okay. These are the differences between proved, disproved and not proved. It is available in your material. You can go through it. It stated about the same things that I have explained to you. Okay, thank you. I would be dealing with the next unit in the further classes. Okay, thank you.